Similarly, privileges created by act of Congress are not within the scope of these rules. These privileges do not assume the form of broad principles. They are the product of resolving particular problems in particular terms. Among them are included such provisions as 13 U.S.C. Section 9, generally prohibiting disclosure of census information and conferring a privileged status on retained copies of census reports. Concerning Rule 501, privileges recognized only as provided, except as otherwise required by the Constitution of the United States or provided by act of Congress, and except as provided in these rules or in other rules adopted by the Supreme Court, no person has a privilege to 1. Refuse to be a witness, or 2. Refuse to disclose any matter, or 3. Refuse to produce any object or writing, or 4. Prevent another from being a witness or disclosing any matter or producing any object or writing. Did you steal my electronic census record as a way to try to create some by process whereby you could justify trafficking me as a violation of my constitutional rights up to and including the 13th and 14th Amendments? I see. Well, let's get to this here, because this is something that's been discussed and we're going to be discussing more on the record in public. B. A large measure of forum shopping is recognized as legitimate in the American judicial system. Subject to the limitations of jurisdiction and the relatively modest controls imposed by venue provisions and the doctrine of forum non-conveniens, plaintiffs are allowed in general a free choice of forum. Diversity jurisdiction has its basic purpose the giving of a choice, not only to plaintiffs but in removal situations, also to defendants. In principle, the basis of the choice is the supposed need to escape from local prejudice. If the choice were tightly confined to that basis, then complete conformity to local procedure as well as substantive law would be required. This, of course, is not the case, and the choice may in fact be influenced by a wide range of factors. As Dean Lloyd Ladd has pointed out, a litigant may select the federal court, quote, because the federal procedural rules, the liberal discovery provisions, the quality of jurors expected in the federal court, the respect held for federal judges, the control of federal judges over a trial, the summation and comment upon the weight of evidence by the judge, or the authority to grant a new trial if the judge regards the verdict against the weight of the evidence, end quote. Ladd, Privileges, 1969, Arizona State LJ 555564. Present Rule 43A of the Civil Rules specifies a broader range of admissibility in federal than in state courts and makes no exception for diversity cases. Note should also be taken that Rule 26B2 of the Rules of Civil Procedure as revised allows discovery to be had of liability insurance without regard to local state law upon the subject. I have the appeal. I've had the appeal since December 2019. And before that, I had an appeal going all the way back to April 2020. And before that, I even had an appeal going all the way back to March of 2019. But over and over again, the process is intentionally sabotaged because the whole point is to never get to the charges. The abuse of the process is so egregious. It is a consistent criminal conspiracy. It's been proven over and over again. If you lacked jurisdiction because you were attempting to extort a kickback, or you were attempting to extort complicity into cooperation with local acts within a larger pattern of racketeering activity, then you don't have authority to keep inserting yourself into the process because everything you've done thus far has been evidence. I was the one that was put into the role of needing to represent myself pro se in prosecution of crimes, of actual criminal charges. Please remember that.